A lawyer called Paul Britton has publicly entered the debate on the Lucy Letby case, and he seems to echo the same manner and similar talking points to those that have been brought up by Christopher Snowdon over the last year, as Snowdon has become the media and social media's most prominent supporter of the Lucy Letby verdicts. Both commentators appear to have a very self-confident, arrogant style, even when they are making arguments which do not appear to me to be cohesive at all. I would say at this point, Snowdon is more knowledgeable about the case, having talked about it consistently over the last year. So to look at both commentators' favourite talking point, which is the length of the trial.
What's the smoking gun? What's the one piece of evidence that you think is most compelling, or you think convicted her? It's I'm afraid a silly question in a 10-month trial.
It was one of the longest trials in all of criminal history in this country.
Snowdon, I suspect, was initially using this argument in place of doing his own research on the case, and I think Paul Britton is using this argument in much the same way. Throughout his most recent interview on GB News, Paul Britton repeatedly used this argument rather than engaging with any nuance. However, the couple of times Paul Britton makes a more expansive statement, he appears to stray into the realm of fabrication.
We are talking about, everyone's trying to isolate this into one piece of evidence, the medical evidence. There was more than just medical evidence. There was forensic scientists.
He seems to be referring to some kind of non-medic forensic scientist, but you can see the list of expert witnesses from the Court of Appeal decision on the screen, and every single one has a medical degree with further training and a different area of speciality, so I have no clue what he's talking about and suspect he's just made it up. In another statement, Paul Britton once again reveals his lack of familiarity with the talking points surrounding the Lucy Letby case.
You just said that he spent 10 minutes over one piece of document, so it wasn't 10 minutes, was it? There was 15 counts.
He shouts down the idea that lead prosecution expert witness Dr. Dowie Evans came to a decision in 10 minutes. However, those who have been following the case will notice Dr. Evans has said he made a decision in 10 minutes and hasn't looked back.
Immediately, I think within 10 minutes or so of arriving and having a look at these notes and over the coffee, oh my God, this baby is the victim of inflicted injury.
So I think there's a chance Paul Britton is just being obtuse and pointing to the fact that the cases were discussed for more than 10 minutes in court. For most subjective commentators, the fact that the lead prosecution witness decided to declare inflicted harm within 10 minutes is a huge red flag, and I think the more likely explanation for Paul Britton's arguments is that he is simply unaware that the lead prosecution witness has made this statement. The next falsehood from Paul Britton relates to an assertion he makes about what was discussed during the trial about the infection risk on the unit.
There was infection on that ward, which has never been actually spoken about. There were sanitary conditions on that ward. There were doctors
all
that were
of
not
these
available.
issues were well ventilated at the trial.
It has emerged since the trial that there were several positive tests for viruses and bacteria on the unit, either just before or during the indictment period. You can see underlined in red due to this risk report, which has surfaced due to the Thirlwall inquiry. Pseudomonas, as in the bacteria Pseudomonas, is in several taps in the neonatal unit. This risk report was completed on the 20th of May 2015, just prior to the start of the indictment period. Further documentation shows that by December 2015, a tap in intensive care within the neonatal unit had to be replaced. By February 2016, there was a delay in tests to confirm the eradication of the bacteria. More details about infections on the unit surfaced in this article, which was posted in March in Unheard. Reading through this part of the article, they say, quote, "Neither of the juries in Letby's 2 trials was informed that a dangerous respiratory syncytial virus outbreak was ravaging the neonatal ward. This breakout was so severe that it forced the unit's closure to new admissions. On February 18, 2016, the day after baby K, one of the babies Letby was convicted of trying to murder, was moved from Chester to another hospital where she later died." The next infectious bacteria, which should have been discussed at the trial but wasn't, despite what Paul Britton says was Stenotrophomonas maltophilia. Baby I's breathing tube tested positive for this bacteria, which by extension raises the possibility the baby was exposed to and then infected by the bacteria.
And in this case, the surveillance culture revealed a bacteria called Stenotrophomonas maltophilia, and the doctors in the unit were duly notified.
An advantage that Dr. Lee's panel had is that on the panel they had an infectious disease specialist, Professor Joanne Langley, who presumably noted the significance of the exposure to this bacteria. If you go by Dr. Lee, the baby's symptoms, such as the nature of her mucus, were stereotypical for an infection with this bacteria.
There was one baby who in fact was infected with a particular bacteria, and they never understood it, so they never treated it. In fact, the symptoms were consistent with this particular bacteria.
If you go by Dr. Lee's panel, the failure to recognise the significance of this exposure to this bacteria by the likes of Dr. Gibbs had profound consequences.
This was likely a preventable death.
The next statement from Paul Britton is at odds with what other people within his own profession say.
We had King's Counsel representing both parties. They weren't on an uneven footing, they were on an even footing.
Looking at this message from the Criminal Bar Association posted on the 23rd of June 2025, to read through the message posted by Mary Pryor, King's Counsel, Chair of the Criminal Bar Association. Long-term savage cuts across the whole of the criminal justice system have impacted on its ability to enable there to be a just and fair trial. The difficulties are widespread. Equality of arms is a fundamental principle of our system. Every person accused of a crime should have access to legal representation and the necessary resources to adequately prepare their case. The current fees available for expert reports and the current system for forensic science are seriously damaging that principle. Now contrast this with what Paul Britton said.
They weren't on an uneven footing, they were on an even footing.
Continuing with the message from the Criminal Bar Association, they say, it is becoming increasingly difficult to instruct an expert on behalf of the defence in a criminal trial. There are fewer professionals with expertise who are willing to provide reports for the fees that the legal aid agency will pay. Skipping a bit, they say, the prosecution has its own budget and can therefore afford to pay more than the defence. Those who have been following the Lucy Letby case will notice this description echoes the conduct of Dr. Evans, who has been accused of having primarily financial motivations, particularly by doctors within the relevant specialities of paediatrics and neonatology, who have suggested he has been making too many basic errors to be acting in good faith. Continuing with the message from the Criminal Bar Association, it sounds like they actually have the Lucy Letby case in mind. Quote, in child homicide cases and other areas where there are a limited number of expert witnesses, it is proving impossible in some cases to instruct any expert within the UK who is able to consider and challenge the prosecution evidence, where experts are only willing to be instructed by the prosecution. It is a growing concern that their evidence, whether consciously or subconsciously, fails to be impartial. So next to look at some statements from Christopher Snowdon, which I don't think add up. I'm not sure exactly what his motivations are for taking interest in the case, but it seems like he has a particular disdain for conspiracy theories. It sounds like in his view, all conspiracy theories have this level of credibility.
As embarrassing as it is, me and Sebastian believe that the royal family were lizards, shape-shifting lizards that crossed across dimensions.
The problem is, he finds himself now potentially on the opposite end of a conspiracy theory. The conspiracy theory being that a group of internationally renowned specialists would act in bad faith to free a nurse who murdered 7 people. To back up to one of Snowdon's first articles on the case, is Lucy Letby innocent? Almost certainly not. He initially says he's not prepared to do any research on the case, saying, quote, I am not going to go down a rabbit hole for the sake of a convicted child murderer. He also reveals most of his views have come from the Daily Mail podcast. Snowdon says of the podcast, quote, It was put out in real time, so had to be studiously impartial for legal reasons, which I think is a controversial statement. The podcast might have technically made sure everything they framed in quotation marks was a quote from the court. However, in many cases they have been accused of not including the full quotation or giving far more time focusing on the prosecution rather than mentioning the defence. It is also now known that the Media Factory, the company behind the podcast run by Caroline Cheetham, and of which Liz Hull, the other podcast host, is an employee, have a financial relationship with Cheshire Police, having been paid by the police for publicity. Information about this has been released by the Cheshire Police and Crime Commissioner and has also been covered in the Telegraph. I'm not saying the Daily Mail podcast was explicitly bribed by Cheshire Police to produce favourable content. However, in my opinion, with the podcast host having a financial relationship with the police, they were disincentivised to give much time to the defence case, which was critical of the police investigation. The defence case would presumably have come to the irritation of the same police force who the Daily Mail were doing business with. In my opinion, for whatever reason, the Daily Mail podcast was a heavily biased podcast. In his more recent comments about the case, Snowdon has been saying he doesn't believe the case has much of a chance of going back to the Court of Appeal.
I don't think it has a cat and hell's chance of going to the Court of Appeal.
His basis for this is that some of the talking points brought up by Lucy Letby's new defence experts were brought up at the original trial.
When the doctor performed the aspiration of the abdomen, the needle perforated the liver.
This is true to an extent, although I think Snowdon gets confused here. More recently still, Snowdon has become more receptive to the chances of the case at least making it to the Court of Appeal, as he seems to have become aware of the Colin Campbell case in the last few days.
The fact that the CCRC, Criminal Cases Review Commission, did hand that over to the appeal court, that makes me think that actually maybe they will push through the Letby case because of the similarities.
So at this point, I would like to play this clip from the mother of Colin Norris, or Colin Campbell as he's now known.
And a lot of the research and everything that we've got it wasn't available at the time of the trial.
So if you go by this principle, this is generally an argument that the Court of Appeal will accept as a ground which can trigger an appeal if there is significant new research which was not available at the time of the trial. Paul Britton is obviously not aware of this because he seems to be ignorant of the issues in medico-legal cases, and Snowdon has also clearly been unaware. There are several examples of the new research is new evidence principle. An example I've used is the case of Angela Cannings. She is a mother who was convicted for the murder of 2 of her children in 2002. In 2003, just a year later, that conviction was quashed. Reading through this line from the Court of Appeal judgment, quote, "We must immediately note a substantial body of research not before the jury and received by us in evidence, suggesting that such deaths can and do occur naturally, even when they are unexplained." In the Angela Cannings case, new research, along with other factors such as a wider examination of her family tree, led to the quashing of the conviction. In terms of the most recent Colin Norris appeal, new research as new evidence was the sole basis for the appeal. Reading through Chapter 37 of the most recent Court of Appeal judgment, quote, "The appeal is pursued in terms that the new evidence is at the frontier of scientific knowledge and is groundbreaking, acknowledging the summing up to have been meticulous. Nevertheless, Mr. Mansfield KC stated that the jury had been left empty-handed and deprived of the benefit of the evolution of understanding and knowledge about hypoglycemia, as now advanced by Dr. Hopkins and Dr. Croxon, which calls for a holistic approach to the symptomology and explains the possibility of natural causes to account for the hypoglycemia." Looking at another statement from the mother of Colin Norris, or Campbell.
It wasn't available at the time of the trial, so there might be more stuff that will come in the future.
Well, as it turns out, there is an overlap in the new research that can be applied to the Lucy Letby case, and potentially going forward in an appeal for Colin Campbell. As far as I can tell, Colin Campbell's team did not make full use of the new research that was available to them. Mary Pryor mentioned at the start of the video about how it's becoming hard for defendants to pay an expert witness's wages in a Crown Court case. By the time you're at a CCRC application, without knowing the exact financial details, you would think it'd be even harder to hire an expert witness. Looking at some of the new research, which calls into doubt the idea that any patient was poisoned intentionally or accidentally in the Colin Norris or Lucy Letby cases. Study titled Insulin Immunoassay Interference Due to Human Anti-Mouse Antibodies in a Patient with Ketotic Hypoglycemia. I've been through this study about antibody interference in more detail in other videos, so I'll do a quick recap here. On the center left column, you see the insulin measurement, and you can see a fairly high number of 48.1. In the middle column, you have the insulin measurement by LC-MS, liquid chromatography mass spectrometry, a more modern and superior technology, and the real measurement is actually undetectable. I say undetectable in the sense that the insulin was actually so low it was undetectable by the superior test. In short, the issue with the immunoassay test is that in some people, antibodies from the human immune system bind with proteins in the test, causing false positives. The other piece of new research is Dr. Shu Lee's new research on air embolism, which casts doubt on most of the verdicts in the Lucy Letby case. So when Snowdon makes the argument that certain arguments are a rehash of the original trial,
when the doctor performed the aspiration of the abdomen, the needle perforated the liver.
This is only relevant if the rehashed, perhaps boosted up and more detailed arguments are being used to try to trigger the appeal. Looking at the Colin Norris appeal, the appeal courts say, as one of the grounds for rejecting the appeal, the defence could not offer any alternative explanation as to how any of these patients had developed hypoglycemia as a consequence of natural causes. So hypothetically, guessing how a Lucy Letby appeal would play out on the Baby O case, Dr. Shu Lee's new research on air embolism would cast doubt on the safety of the verdict, which would provide the pretext to reopen the case. Once the case is reopened, the defence are then able to put forward their alternative case theory that the baby suffered a liver injury inflicted by one of the hospital consultants. Snowdon again argues under the impression that anything mentioned at the original trial can never be mentioned again when discussing the conspiracy theory that Lucy Letby was the victim of 4 hospital consultants who were looking to pin their mistakes on her.
Alleged there was a conspiracy of 4 consultants, and that is what her defenders believe. They don't realise that was Letby's actual defence.
Once again, it's apparent this can be reconsidered if there is supporting evidence which was not available at the time of the trial, although this might be too controversial an approach for the defence team to take an appeal. If they did want to go down that route, then the email in this Unheard article, hidden email cast doubt on Lucy Letby verdict, could be significant. Just to do a quick recap, in the email Ravi Jayaram is quoted as saying, "Staff nurse Letby at incubator and called Dr. Jayaram to inform of low saturations," close quote. I should say that not everyone who thinks Lucy Letby is innocent believes she is the victim of a conspiracy. Some people point to a statistical coincidence and the medically unexplained nature of the deaths at the time, later fueled by confirmation bias, as the reason for the allegations against her. I should also point out this statement by Dr. Gibbs.
Lucy Letby was wrong. It wasn't a gang of 4, it was 7.
I think if you are the victim of a conspiracy, you wouldn't necessarily know who and when was working against you. Similarly, for someone like me observing from the outside, I can only speculate who knew what and when. Although a number of emails and other evidence have been made public since the trial that points to shady conduct from the consultant body. The email by Ravi Jayaram is relevant to the conspiracy theory because it went to 6 other members of the consultant body, or Dr. Gibbs' Gang of Seven. Even though Dr. Gibbs' Gang of Seven should have known that Ravi Jayaram was either lying or very confused under oath, none of them have ever brought this up in relation to their knowledge of this incident. As this email was not known about at the time of the trial, it is very likely to constitute new evidence. I believe it is very likely to lead to the quashing of the Baby K conviction. As far as the idea of the conspiracy against Lucy Letby, it seems less likely it would have an impact on that. But in my opinion, Snowdon's commentary on the conspiracy theory,
and that is what her defenders believe, they don't realise that was Letby's actual defence,
suggests that he can dismiss this argument because as it was raised at the first trial, it can now never be mentioned again, even if there is new supplementary evidence to support the argument. In terms of the wider Lucy Letby case, it has also been argued there were a number of disclosure failures by the prosecution, which could also lead to new arguments being brought, or arguments at the first trial being reconsidered with the new supplementary material. So on a closing note to this video, I will say that Paul Britton might be a good lawyer in other areas of the law. His commentary on the Lucy Letby case seems enormously overconfident. He seems to have very little knowledge of the case and a poor knowledge of medico-legal cases in general. Christopher Snowdon has more knowledge of Lucy Letby trial trivia, though he has very little knowledge or training in the areas of science and medicine. Further, he seems to be confused about the legal procedure.